So my name is David Lekerai. I'm a partner in the corporate practice at DLA Piper Africa. That's IKM Advocates locally. I'm quite honored and happy to have the opportunity, of course, to take us through this session, focusing mainly on acquisition of the assets. We've obviously, in the morning sessions, looked at the whole framework of what a REIT really is. And I really quite like the analogy that was given to us by, I think it was Eddie from NCBA, that if you understand unit trust, it is really a unit trust, but ultimately the differentiator or the key difference is the fact that you are dealing with real estate. The assets that it's supposed to acquire, own, and deal with, or even dispose, is real estate. Now, okay, thank you. So I think quickly touching on the legal framework, the main legal framework here, and I know someone will be taking us through the entire legal framework of REITs, but for purposes of acquisition of the assets, it's really the REITs regulation, the 2013 regulations. There was a slight amendment last year, and that's really the focus of today's discussion. Obviously, we can't mention the regulations or what is typically known as subsidiary legislation without making reference to the parent act, and that is the Capital Markets Act. I see there's a bit of a typo there. We're calling it Chapter 485. It's actually Chapter 485A, capital A, for those that... yeah, okay, thank you. Now, in looking at the acquisition framework and acquisition mechanism, I think it's important for us to really understand what is the focus of the acquisition. What are the eligible assets? And the first one, according to the regulations, it's a freehold property, real estate. That is basically land that has no limitation in terms of the tenure or the period of ownership. In addition to that, and I'm talking about the underlying assets, you then have leasehold property, but the rider is they must have a minimum period, an expired period of 25 years. And then, in addition, and that the last two actually related in a way, it's more of a structural framework in terms of the difference rather than anything else, is properties under the section of properties regime, and even those, of course, are required then to have an expired period, a minimum unexpired period of 25 years for them to qualify. Now, so those are the underlying assets that must be owned or acquired by a real estate investment trust. But it can do so, the acquisition, either directly or indirectly, and that's why you then have the various frameworks or acquisition vehicles, special purpose vehicles, if you like. And some of these have been mentioned actually in some of the previous sessions. The first one is an investee limited liability company, an entity that is incorporated under the Companies Act. And the key requirement there is it must be owned by the trustee. The trustee, actually, the key role of the trustee is, in terms of the legal ownership and the beneficial ownership, as has been mentioned, on behalf of the unit holders or investors in a REIT, that is the legal owner of the properties, who then acts on behalf and in the interest of the REIT owner. So you have the investee LLCs, investee limited liability companies, but you can also, under the overall trust, then have an investee trust. But apart from that, the third one, which is not directly or specifically mentioned currently in the regulation, is an investee limited liability partnership. Now, the relevance of that is, under the applicable law, that is the Limited Liability Partnership Act, it is actually a corporate entity. And it bears all the characteristics in terms of being able to own property and to enter into contractual arrangements that a limited liability company has. And accordingly, the regulator then recognized the fact that, well, while the regulations just mentioned, and that's one of the beauty of having a practical regulator who is able to understand some of these things, while the regulations only makes reference to a limited liability company, they then, of course, accepted the limited liability partnership as well. Obviously, it would be neater, and I expect this to happen at some point, for the regulations to be updated. Then lastly, of course, there is the opportunity for the REIT as well to invest in what is called real estate related, in entities that undertake real estate invested activities, such as property management and the like, but there is a rider there. It must not be more than 10% of the total asset value. I need to master how these things move. So quickly then, in terms of the acquisition methods, having mentioned the fact that an acquisition can happen directly or indirectly through a corporate entity that is owned and controlled by the trustee, you are then looking at two methods of acquisition. The first one, and let me start with the one on the right side of the screen, is a direct acquisition, which basically involves the trustee itself entering into the contract for purposes of acquiring an asset. So a certain property has been identified somewhere. Instead of the trustee acquiring through a corporate entity, they then enter into a sale agreement or an acquisition agreement with the landowner, the seller, to acquire that property. The first one, which is on the left side then, applies where the acquisition is happening through the corporate entity. So you have the trustee at the top. The trustee owns the corporate entity, or rather, the seller of the asset has registered a corporate entity, either a limited liability company or a limited liability partnership, and I'll continue now using the words LLP or LLCs, and that entity then holds the assets, okay? And probably it owns a couple of other things, the assets, maybe some employees, maybe some contractual arrangements. So instead of acquiring the asset directly, you then acquire the unit of ownership in that corporate entity. If it's a company, then you'll be acquiring the shares. If it's an LLP, then you'll be acquiring the units in that LLP. So what are some of the key considerations then? Maina, do you have that micro? It looks like I might have to step here to be able to follow the screen properly and work with the team. Thank you. So having seen then the acquisition methods, some of the key consideration, of course, is the time of acquisitions. And you need to look at it or rather, it typically works out in three perspectives. So at the point of initial registration of the REIT, you're then required to have made an investment, at least one investment, and this is actually required as part of the fundraising within 180 days. So that's the very first one. And then on an ongoing basis, obviously, you will then have the opportunity to make additional acquisitions and divestment if you're selling the assets. Now, for an A REIT, it's required to have made at least 75% of the total asset value in real estate within 2 years, and for a D REIT, 30% within 1 year. So that is just in terms of timing. Some of the considerations applicable have already been mentioned. Structural engineer reports, valuation report, that is a must, and that actually guides the pricing, because in making an acquisition, the purchase price when you're acquiring must not be more than 1.1 times of the valuation in the valuation report. So 110% basically, it must not exceed. When you are making, and this is basically a way of protecting investors. When you are selling, on the other hand, and you cannot sell it at a discount, and if you do, it must not be at less than 90% of the valuation that is in the valuation report. No encumbrances, although of course the trustee can approve, depending on how that has been structured. And in some of the existing bonds, actually, we have had situations where assets have moved to the REIT with encumbrances. These are basically the charges in favor of financials and the like. Some additional approvals may be required depending on the threshold. I'm seeing this clock is really, really moving. Now, what is the acquisition process? We'll quickly look at the preliminary, due diligence, contract drafting and completion stage, and then touch briefly on post-completion matters. Now, in terms of the preliminary stage, obviously identification of the property, that is key. I think that's really what business people are good at. And then once you identify, you then have the preliminary documents, typically non-binding, but they then give an opportunity for the parties to negotiate the commercial terms. And it also facilitates, because you then have at least a basis on which to move to negotiation, it then facilitates due diligence, and we'll shortly look at due diligence. And then after that, of course, the negotiation and the rest of the transaction timetable, which we'll quickly touch on shortly. Now, what are we looking at in terms of due diligence? So basically, due diligence is really trying to understand the assets that you want to acquire. It could be attractive. Kenyans, we know, especially not the Gen Z generations, those who used to, whenever you get money somewhere, you then run to somewhere in Kitengela to acquire land, just without really having applied yourself whether that it's a good investment opportunity or not. It's just the way it's been happening. But in the context of a REIT, you actually need to do a lot more than that. Obviously, you need to do the title investigations. The surveyor, of course, needs to do their work and properly ascertain ownership or a structural framework relating to ownership of that particular property. For a property that is already constructed or in the construction process, matters such as environmental audits are critical. Contractual obligations that are there, those are critical. And you'll require a number of service providers actually to be able to do that. For title investigation, maybe lawyers and surveyors. Contractual arrangement, of course, lawyers, environmental audits, they're experts in that, and evaluation as well. Now, after due diligence, you're happy with the property, you're happy with the contractual arrangements. If, say, you're acquiring the corporate entity, you ascertain that there are no legacy issues that are not undesirable rather. There are no outstanding tax issues, for example. There are no outstanding litigation, for example, because it could be a wide framework of issues that needs to be considered. You then move, of course, to the contracting stage. So preliminary, you have your head of terms, you have your preliminary agreements, due diligence, and now you go to the real acquisition stage. Now, the acquisition or negotiation stage rather addresses some of the issues we've identified in the due diligence. Encumbrances, if there are encumbrances, how do you deal with those? Do those move with the assets, or do those need to be unwound? Of course, the purchase price mechanism, including when it's supposed to be paid, approvals that are applicable. It could be approvals of counterparties, maybe lenders and the like. And then there is a mechanism, let me just quickly mention that, one particular item, there's what is called seller disclosure letter. So the disclosure letter, as part of the acquisition, you are getting what is called warranties. And basically that is a number of statements given to you by the seller to say that this property is okay, this corporate entity is good, there are no underlying issues that could expose the company. So that is the comfort they give you. However, they then get an opportunity to give you a disclosure letter to say, however, there are a couple of things that you need to know. For example, there could be an outstanding tax liability with the KRA or a tax dispute with the KRA. Then you need to factor that in terms of the commercial deal. Does it still make sense to me? Should I ask for an adjustment of the purchase price, or should I ask for an indemnity or any other protection? Now, so what is the share purchase? So share purchase, just going back again to the acquisition methods, we mentioned the direct and acquiring a corporate entity. This will be applicable when you're acquiring a corporate entity. And it can take several names. You could call it a share purchase agreement for a company, or a partnership interest acquisition agreement or purchase agreement for an LLP, and so on and so forth. So basically, it sets out all these issues. The shares, which is really the unit that you are acquiring, the consideration, and that is critical. Remember some of the thresholds we referred to earlier. The conditions, including, of course, any approvals that is required. If it's an IREIT and say you're acquiring an ongoing business or a property that basically has been in operation, is it the case that that is considered as a business from a competition perspective, and as such you may need to assess whether approval from the competition regulator is applicable. Warranties and indemnities, I've already mentioned that, and then tax covenants and so on and so forth. Limitations, that is critical. That is basically some of the tools the seller would use to limit their liability, and as a purchaser, you need then to know how to deal with those, so as, of course, at the end of the day, make sure that you've actually acquired the asset, what you thought you were acquiring. You've acquired the company, and the asset, the underlying asset, is in fact owned by the company. Asset purchase, now this applies when you're making a direct acquisition of the property. And it could be a lot more, because if, say, you're acquiring a building that has a number of other, it has a contractual framework that is that already is applicable to that building. Let's say the security contracts with the security providers, the cleaning contracts with your cleaners, and so on and so forth. You need them to figure out or agree with the seller whether those are moving, and then probably that would require a bit more action for you to do that. At the end of the day, once you've agreed, this would require some registration at the land office. Before registration, obviously payment of applicable taxes, and so on and so forth. I've already, if it has employees, you probably also need to agree on how those are dealt with, because in Kenya, under the Kenya legal framework, we do not have a mechanism where the employees move directly with a new owner of a business or a property. Now, ancillary documents that are applicable to either of the two, share purchase or asset purchases, some of them could be mechanical, and these are what are registered at the company registry or at the land registry. Share stock certificates for company registry, property transfer property transfer documents at the land registry, IP registration, if intellectual property is also moving. Corporate authorization, this is critical, and actually at due diligence stage, you are able then to identify what sort of authorization are required. And then the filing are those three registries typically: company registry, land registry, and the Kenya Industrial Property Institute for intellectual property, where, say, trademarks that are attached to that particular property are moving. Now, post-completion, obviously this is just the usual cleanup. I mean, you've now owned the asset, it's yours, you can record it in your books, but there are a couple of other things that you just need to finalize to be able to tie up the whole process. Already mentioned registration, assignment of leases and contract, that is also important, notification to tenants of a building and other relevant people, and then closure or transfer documents and termination of any outstanding contracts. And then, of course, for the vendor, there's a payment of the purchase price. Key takeaways, the share purchase agreement, you're acquiring everything in the corporate entity, the words and all. So if there is a tax issue, it moves with you unless, of course, you hide that out. If there is a contract that the company is party to, that moves with you. For an asset or business purchase agreement, you'll then be acquiring specific assets, okay? So if it is a land, you're then acquiring that specific land. If that land probably has security and an encumbrance, a charge created against it, then that probably would also move with you. So it is very specific. Disclosure letter, it precludes certain matters that are addressed in the warranties, the comfort that have been given to you in the warranties. And then you may want a transitional services arrangement, particularly for an existing business, an existing property or building that has been constructed. How do you deal with Kenya Power bills, for example? How do you deal with the utility bills and so on and so forth? And then last but not least, ancillary documents. These are really the documents that are applicable to transfer the assets and what needs to be done for registration purposes. And I think that's it in terms of time. Sorry, I've had to rush, but I really wanted to honor Miner's restrictions here. Happy to answer any question, but otherwise, of course, we're still here and we'll be able to.
Well done on. So let's appreciate it with a clap, please. Appreciate it. I think he was a debater back in your years. You ended on just the exact zero you were.